These are protesters gathered outside the Erika Kirk event called Make Heaven Crowded. It's her tour stop in Riverside, California, which is in Southern California. And as the event got underway, demonstrators holding signs and chanting outside the venue while attendees continued inside. No arrests were reported in the case. And in Utah, Erika Kirk is taking a new legal step in the case against the man accused of killing her husband. She's filed for a speedy trial in the case against Tyler Robinson, who's accused of shooting her husband that day in Utah as well. Legal experts say the move is common in murder cases and serves as a formal reminder that victims also have a right to a timely resolution under Utah law. In court filings, Kirk's attorney accuses the defense of causing undue and unwarranted delays, saying justice should not be dragged out. The case remains pending with no trial date set.
And this comes as Robinson appeared in a Utah courtroom less than a week ago. His lawyers alleged a conflict of interest in the Utah County Attorney's Office. They say an adult child of one of the attorneys was at the Utah Valley University event where Kirk was assassinated. Documents say the child, who is a student at the school, was less than 90 feet away from Kirk when he was shot. Well, the county attorney's office denies the claim, saying the 18-year-old in question did not actually see Kirk when he was shot and also did not see anyone with a gun. So let's take a legal deep dive into this case. Attorney Josh Colesrud is back with us again. Would this actually be a conflict of interest?
No, it's not. And what the defense is doing is what they're supposed to do on any capital case, which is challenge every type of issue that is brought to light. So here you have Utah Rule of Professional Responsibility 1.7, which states basically that a prosecutor has to be materially involved in a case such that he would be a witness or he would have some type of evidence that isn't discoverable that could somehow affect his judgment. Now, having a son who is an eyewitness.
Right, that's removed.
Yeah, now, optically, yeah, you probably don't want to see that, if you're the public. But does it require that he disqualify himself or the office has to disqualify themselves? Absolutely not. And I expect that the court is going to deny that motion fairly quickly.
So again, just bottom line, if the prosecutor was at the school when it happened, then that would be a whole different scenario. That would be a conflict of interest.
Well, not just at the shooting, but a material witness where he would definitely be called regardless if he was the prosecutor or not. Now, there's thousands of witnesses there. So his viewpoint would need to be such that he knows or saw something that most people wouldn't see. Now, that would be a hypothetical that would probably kick him off.
So do you think this is just a delay tactic?
No, I don't think it's a delay tactic. I think that
it's legitimate.
It's a capital case, and you have to challenge these findings because it's going to be appealed, and what you don't want as a defense attorney or as a prosecutor for an appellate court to say that there was ineffective assistance of counsel because they didn't challenge something, and which is going to happen in this case. So they have to dot all their I's and cross all their T's.
All right, got it. Josh, thank you so much for your insight on all three cases.
Sure, no problem.
Okay.